Welcome everyone to today's webinar on supporting vulnerable victims and witnesses. I'm pleased today to co-host the webinar with the Canadian Network for the Prevention of Elder Abuse. And we are pleased to have our speaker, Megan Vis-Dunbar, who's a staff lawyer at the Canadian Centre for Elder Law. Before we begin, I do want to provide our land acknowledgement. We acknowledge that we gather on the traditional territory of a number of First Nations and acknowledge their stewardship of this land throughout the ages. We seek a new relationship with the original peoples of this land, one that is based in honor and deep respect. Just want to go over just the framework for our discussion this afternoon. After the intros, we will give you just an overview about what we're doing, a little bit about who our organizations are with Elder Abuse Prevention Ontario and the Canadian Network for the Prevention of Elder Abuse. We'll introduce our speaker, who will then give her presentation. We will leave time at the end to do a question period. So please post your questions in the question box. And we'll talk a little bit about some of the upcoming events that we're hosting, some resources, and then how you can contact the speakers in our organizations as well. I do want to acknowledge that we are hosting a series of webinars in recognition of Victims and Survivors of Crime Week, to raise awareness about issues facing victims and survivors of crime and the services, programs, and laws in place to help them and their families. So this is the first of webinar. We're hosting another one next week, and we'll talk about that at the end. If you want to go onto the website, this is funded through the Department of Justice Canada. They have a number of resources, and they are also doing their own webinars as well, where we just actually did a presentation this morning on safety planning. So there's a series of webinars that we encourage you to also participate in during this week. Just some logistics for today. Everyone will be on mute during the session. As I mentioned, we do encourage everyone to put their comments in the chat box. If you have a specific question, put that in the Q&A section, and Benedict will be moderating that and watching that throughout the presentation and hosting the Q&A at the end of the session. We do have ASL interpreters with us today, so they have been pinned, so you can also change the layout on your own screen. There's a grid at the top of your screen that you can change the layout according to the view that you would like to see on your screen. We have also enabled closed captioning, so you can turn that on or off on your own personal screen as well. We do appreciate your feedback at the end of the session. If you wouldn't mind filling out an evaluation, it takes about 2 to 3 minutes just to give your input and maybe ideas for future sessions. We'd really appreciate that. As I mentioned, we are recording the webinar, and it will be posted on our website and the Canadian Network website within the next day, and that will be accessible for people to get, as well as any of the links or documents that are shared during the session today in the chat box. They'll be posted on the website for people to access and have quick accessibility, so they can download those as well. We do appreciate people's privacy and confidentiality during these presentations that we do. We know that it may generate some discussion around maybe circumstances that is yourself or someone that you may know. We do ask that you keep questions more in a general sense, and that when you do post them, if you would like to speak to us after the session to give more details about a situation that you want some support in, we would be more than happy to support you. Please contact us. As I mentioned, our contact information is at the end of the presentation today, so please feel free to reach out to us, and we will provide that more confidential conversation about a personal situation that you may be incurring. So just a little bit about our organization, Elder Abuse Prevention Ontario. Our mission is to make sure that seniors are free from abuse, have a strong voice, and feel safe and respected in their communities. Our organization has been around since the late 1990s, and we have been doing many activities and initiatives to work towards that goal. We work with our partners in communities, both regionally, locally, nationally, sometimes internationally, to enhance the service and response to elder abuse prevention. In 2003, we also were given the mandate to implement Ontario's strategy to combat elder abuse. So that is funded under the Ministry for Seniors and Accessibility. So we are a nonprofit organization, but accountable to the ministry to implement the strategy each year. And we have goals under that strategy, which include public education and awareness, frontline training, and community coordination and response. I'm going to turn it over to my colleague Benedict, who's going to talk a little bit about her organization and then introduce our speaker.
Good morning, good afternoon, everyone. My name is Benedict Schöpflin. I'm the Executive Director of the Canadian Network for the Prevention of Elder Abuse, known in short as CNPEA. CNPEA, as you may know, is the sole pan-Canadian network for the prevention of elder abuse. We exist as a form of connector between provinces and territories, between services and organizations that do a lot of great work across the country. And our focus is really to foster the exchange of reliable information, just knowledge sharing, connect people and organizations so that they can better work together and provide better support to people who need it, and to advance program and policy development on issues related to elder abuse prevention, as well as, I will add this in a mix, ageism, which has become obviously over the years a growing focus of ours. So we do this work at the local, regional, provincial, territorial, and national level. We're involved with many wonderful partners, including the organizations represented today. CCEL has definitely been a long-term partner of ours, or at least a collaborator of ours. So we are very happy to welcome Megan today. I invite you to check out our website, www.cnpa.ca. That is where you will find a hub of information. So you can find not only resources, reports, brochures, but also a find help section that is curated by province and territory. If that is what you're looking for, it is easily accessible at the top right-hand side of your screen when you get to our website. On this note, I think I will introduce Megan. All right, and I'll just, perfect, thank you. So Megan Vis-Dunbar is a staff lawyer with the Canadian Centre for Elder Law and the British Columbia Law Institute. She is working on a project to create guidance for supporting vulnerable witnesses, which is what we are going to talk about today. She's also leading research on the Reconciling Crown Legal Frameworks program. Prior to joining the BCLI and CCEL, Megan worked with the Courthouse Libraries BC, where she coordinated the legal continuing education program. So Megan has over 10 years of experience practicing in the areas of criminal and constitutional law. And today she's going to tell us more about that project of hers. Now, Megan, I'm going to mute myself and go off camera. The screen is all yours. And a reminder for all our people listening today, if you have comments, resources to share, use the chat box. If you have questions for Megan, put them in the Q&A box and we'll deal with them at the end of the presentation. Thank you so much.
Great, thank you. And just checking that. Okay, so now my slides are up.
It's perfect. It's good.
Great, thank you. Thank you for that introduction. I do want to acknowledge that I am a settler joining you today from the traditional and unceded territories of the Musqueam, Squamish, and Tsleil-Waututh nations. I'm grateful to the stewards of this land and will do my best to work in solidarity towards Indigenous sovereignty. I do want to try to leave some time for questions today, so I may skip over a few things a little bit quickly here to make sure that we do have that time. So I'm just going to put my outline up on the screen there so that you can read it and won't go through it in much detail. I'll go on to the presentation. I do want to note before getting started that the information I'm providing today is just that, it's information, not legal advice. I also feel it's important to make a note about language. So I will refer to victims, complainants, and witnesses, which are all terms used in the legislation and policy to refer to someone who testifies in court. And victims in particular is commonly used in the policy and legislation. I do recognize that not all complainants identify with that language choice, and I do want to acknowledge that. I also know that we have people joining from all across Canada, I believe, and so when I am referencing policy, I will be referring to policy that applies in BC today. There are different prosecution policies for different provinces and territories. A bit about the Canadian Centre for Elder Law. So the CCEL conducts research and develops reports and educational tools about legal and policy issues related to aging, and it is a part of BC's nonprofit Independent Law Reform Agency, and our website is up on that slide there. I'd like to set the stage a little bit to contextualize the discussion of capacity and competency in this context. So in the field of elder law, we often refer to capacity or capability assessments. And within the criminal justice system, the key capacity consideration is testimonial competency. So the law can place limits on who is competent to give evidence in court, and that is governed by the Canada Evidence Act. Under that legislation, all people are assumed to be competent to testify unless one of the parties involved in the case challenges that, in which case they have to prove to the court that there's an issue with the witness's competency. The rules are a little different for adults than children, and I will be just focusing on adults today. So if competency for an adult is challenged, the court looks at whether the witness understands the nature of an oath or solemn affirmation, or if they can promise to tell the truth, and that they can communicate the evidence. It's only if they don't understand the oath and they cannot communicate the evidence that they would be found not competent to testify. There's another assessment that comes into play, which is credibility. So ultimately, judges or juries, depending on the trial, need to decide how believable each witness is and how much weight to put on their evidence. And when a lawyer is trying to decide whether or not a witness should testify, they'll try to assess their credibility. And that's going to come up a few times during the presentation today in terms of how that credibility assessment can play in with some of the factors that contribute to vulnerability and that increase with aging as well. So one of the things that I will note today is the importance of being really clear about each person's roles and responsibilities in the criminal justice system. Many victims see the Crown as their advocate, and one way to support victims is to help them understand each person's role. So this slide shows a little bit of an outline between the police and the Crown. It's really important to note that the role of the prosecutor is to independently present to the court the evidence that they consider to be credible and relevant to the alleged crime. It's not to try and win or lose a case for any particular side. And the decision to prosecute needs to be objective, needs to be not influenced by emotions or prejudices, whether political, from the police, the defense, or any witnesses involved in a case. In BC, when it comes to making that decision, Crown Counsel are guided by policy, which is all published and available online. So in BC, policy sets out a two-part test for Crown to consider in deciding whether to approve charges and prosecute a case. The first part of that test is whether there's a substantial likelihood of a conviction. And the second part considers the public interest in the prosecution. That second part only comes into play if the first part of the test is met. And it's that first step that can be particularly challenging in cases involving elder abuse and vulnerable witnesses. The charge assessment test in BC is a high standard when considered in comparison to other provinces, where the test is sometimes a reasonable likelihood of conviction or reasonable prospect of conviction. In BC, Crown must be satisfied that there is a strong and solid case to present to the court, looking at all of the evidence that's likely to be admitted, how reliable that evidence is, and also defenses that the accused may have. And if that standard is met, that first part of the test, then they go on to consider the public interest. And it's at that stage that the relative vulnerability of the complainant and whether it involves elder abuse would be considered. So I've just noted some of the key BC Crown policies that would apply in a case involving vulnerable witnesses. There are many more policies, and depending on the circumstances of the case, other policies may come into play. And I've provided the link there on this slide for where all of those policies are accessible. The guiding principles I've already touched on a little bit, that speaks to the exercise of discretion of prosecutors and their independence. So I won't go into that into much more detail. The charge assessment guidelines speak to the test I just touched on about whether or not to start or continue a prosecution. The elder abuse policy speaks to the considerations for Crown Counsel when the complainant is elderly. It defines elder abuse as anything from physical assault and unlawful confinement to verbal threats, trade practices, or fraud involving a victim who's 65 years or older. The policy does recognize that elder abuse often happens within a family, which creates challenges for reporting. And for certain cases, it refers Crown Counsel to the Vulnerable Victims and Witnesses policy, which I've also listed here. It offers some suggestions around considering whether or not a peace bond should be considered if charges are not approved. And also reminds Crown to follow up with the police if they have concerns for the safety of the elder and to consider informing appropriate community agencies in that case. The Vulnerable Victims and Witnesses policy applies when there is a reasonable likelihood that an individual's effective participation in the justice system will be significantly diminished or eliminated if accommodations or supports are not made available to address their situation, including a witness's advanced age. So in relation to elderly victims and witnesses, this policy provides some guidance around using additional supports, testimonial aids, and other ways of supporting their participation. I've also included the policy on intimate partner violence in this list as one to keep in mind. It doesn't specifically refer to elders or age as a factor in applying the policy, but research does indicate a gap in the prosecution of elder abuse cases related to intimate partner violence. Dementia in particular has been correlated with an increased risk of sexual violence, particularly for women. However, in cases that have been reported and published, there appears to be a lack of reported cases that deal with intimate partner violence as it relates to elders. So aging can create challenges in getting over that first step of the charge assessment test, as I mentioned. This slide takes a look at some of the reasons for that. And I recognize that aging doesn't follow the same path for all adults, but certain conditions, the likelihood of certain conditions can increase significantly after the age of 65. One of those risks is the rate of mortality, and trials can take months or years to complete. So it is an important thing to keep in mind, the lifespan of the witness. There's also natural changes to the brain and nervous system with age, which can result in a slowing down of thought and memory processes for some adults. There's an increased risk of dementia and severe memory loss with age. The rate of vision and hearing loss increases significantly after the age of 65. And independent of age, I think it's important to understand how memories are formed around traumatic events. So when supporting vulnerable adult victims, I'll talk a little bit about the impacts of trauma, but that can really be compounded with age. So it's estimated that 40% of adults over the age of 60 experience some form of memory loss. That covers a wide range in terms of what that looks like. But when you take the impact of trauma combined with age, there can be increased gaps in memory that affects someone, both in terms of perception of an incident at the time it happens and the ability to recall it after the fact. Age-related issues that can impact mobility include an increased risk of living with arthritis and an increased risk of injury from falls. I do want to note that in BC, at least, each courthouse has an accessibility coordinator to help with navigating the courthouse. So early contact with that coordinator can be important to determine accessibility and whether or not a court order or some direction from the court is needed for further accommodations. There's an increased likelihood of stroke, which can result in mobility issues, difficulties with communicating, as well as memory loss. Also an increased likelihood of dementia. Again, that can result in difficulties with communication, mobility, memory, and visual perception. All of these factors that I've put here also increase the likelihood of someone being vulnerable to being a victim of crime. So if we look here at some of the factors that increase someone's vulnerability to being a victim, I'm just going to kind of leave that up there for you to see some of the different factors that might intersect to increase someone's vulnerability. But in particular, the World Health Organization notes that functional dependence, disability, poor physical health, cognitive impairment, and poor mental health and low income all contribute to the likelihood of being a victim of crime. That can intersect with factors, for example, women who live with a disability who are seniors have a greater rate of victimization than men. Indigenous women are more likely to be victims of crime, and in particular, serious crimes. Members of the Two-Spirit LGBTQIA+ community experience higher rates of violence. And as I already mentioned, dementia has been correlated with an increased risk of sexual violence, particularly for women. So these factors can all intersect. And when we start to look at the impact that that has on people, I do want to acknowledge that this is difficult work in supporting vulnerable witnesses. So a vulnerable witness may be very reluctant to go through the criminal justice system. They may distrust the system and people working within it. They may find it very challenging to speak about the incident, have difficulty recalling details. They may miss meetings and court dates, change their mind multiple times about their participation in the process. And all of these behaviors are normal and understandable, but they do make it challenging and exhausting sometimes to support someone through that process. And so I think that's important to acknowledge. And so how does this all relate back to that assessment of someone's competency and credibility that needs to be made when deciding which witnesses to call in a case? Some of the behaviors I just mentioned, as well as others, mean that a victim may not behave in the way that we expect victims to behave. And I just want to take a moment to consider what assumptions we draw when that happens. So if someone doesn't run away or fight back, they don't report the incident to the police right away, they give inconsistent accounts of what happened or have difficulty speaking about the incident, how does that impact our view of them as a witness? That's just something that needs to, I think, be in your people's minds throughout the whole process of going through the criminal justice system. Because if we see a witness as lacking credibility and reliability because of their behavior and not aligning with how we think it should be for a victim, that can play into that assessment of whether or not there's a substantial likelihood of conviction. And sometimes there just isn't a substantial likelihood of conviction because there's not enough evidence, or the evidence that's available isn't admissible in court. Maybe there's a really strong defense. So it's really important to distinguish between those types of situations and when stereotypes or assumptions about victims' behavior or the impact of trauma on them plays into that decision. And in those situations, we can look at ways to try to support the witness in participating in the process. So when we look at how memories are formed and stored, and how that process is impacted by trauma and age, we can start to focus on communication strategies that support getting a full and honest account from a witness. Unfortunately, often the way that we ask witnesses to recount an event that happened can be problematic. So research in psychology suggests that we can get the best recall of an incident through questions that are consistent with a person's sensory abilities. Sometimes we see witness interviewers fall into a habit of trying to get a witness to recall information sequentially. Questions such as, what happened after X? But if a person's memory hasn't been encoded in that way, or there's gaps, a question framed as, what else can you remember X, might actually help the person to focus on the sensory fragment and expand out from that point in a way that they may not have been able to with the first question. So if we can shift away from expectations of how a story should be told to focus on supporting a witness in recalling the best quality of evidence that they have, we may be able to support a witness through an interview. And I realize that many of the people attending today are people who play a support role, not the person who's conducting the interview. So I point this out as something to keep in mind. Maybe there's a role in helping to explain this to the interviewer, or helping to explain this to the witness themselves if they're able to try and boost their recollection or advocate for themselves in relation to the person who is interviewing them. Another way of helping older adults with their recall can be to suggest that they try to imagine themselves back in the environment where the incident took place. A note of caution about that: if the incident was traumatizing, that this should be done cautiously and with supports in place. But that may be one way of helping someone with their memory recall. And then there's also testimonial aids available through legislation that can help reduce stress and trauma and help a witness to focus on providing that full and honest account of what happened when they're giving their evidence in court. So we'll look a bit at some of those accommodations that are available. These are just some of the accommodations that are available through the criminal code listed here. And I provided a handout, which I think will be posted on the website as well, which lists some of these and some ways to think about how they might support an elderly witness or a vulnerable witness. Both the vulnerable victims policy and the intimate partner violence policy that I referred to earlier suggest that Crown inform the witness of the availability of these accommodations where appropriate. So that note is not made in the elder abuse policy. It is made in the vulnerable victims policy and intimate partner violence policy. So in those situations, hopefully a witness is getting this information from the Crown. But it is really important. And as a support person, you can make sure that a person has this information, that these types of aids and accommodations are available, because it's not solely up to the Crown to ask for the accommodations. So every victim has the right to request a testimonial aid when they appear as a witness in court. They do not need the Crown to make the application. The Crown can make the application for them, but they could do it themselves as well. So there are sections of the criminal code that allow a witness to request to testify behind a screen or from a different location, if that would help in giving a full and honest account of their evidence. And this may help if someone has a mobility issue, which prevents them from attending court. It can also help if a witness is testifying against a family member. If a court order is requested to testify in this way, the court will consider whether or not the accommodation is necessary to get that full and honest account from the witness. They'll also look at the nature of the offense and the relationship between the witness and the defendant, as well as the witness's age. These testimonial aids often aren't employed in cases involving elder abuse. So it would be great, I think, that people give more thought to how they can be employed. There's also options to have a support person or a courtroom dog present. And that type of emotional support may really help a witness in giving their evidence in court. If the defendant is self-represented, a request can be made for the court to appoint a lawyer to cross-examine the witness, which may facilitate communication in that context. Sometimes when an application is made, the court may need to hear why the accommodation is needed. So again, this may be where, as a support person, some information could be provided on that. Support people may be able to provide evidence in that application to help get that accommodation that's going to meet the needs and abilities of the witness that you're supporting. There is also mention in the Canada Evidence Act that if a witness has difficulties with communication due to physical or mental disability, they can apply to give evidence by any means that enables the evidence to be intelligible. So this could potentially help in a situation where a person who's had a stroke or dementia and struggles with communicating their evidence verbally. I think it's worth thinking creatively about ways that support workers and medical professionals can help in providing the court with information about how that person can communicate and focusing on the person's abilities and strengths. If a witness has difficulty communicating their evidence because of a mental or physical disability, the police can also obtain a video statement earlier in the process to help to preserve evidence. So with all of us, our memory of an incident fades with time, and this can happen at a much faster rate with someone who experiences age-related memory loss or dementia. And studies show that the most reliable version of an incident is the one that's told the closest in time to the incident. So if there is an opportunity to suggest that police or the Crown record a statement early on, this may help in preserving the evidence for the trial. There are cases where previously recorded statements have been admitted as evidence in trials involving seniors who subsequently died or were no longer competent to testify by the time of the trial. There's other ways of preserving evidence, not just by video recording. So there may be evidence that's taken during the investigation leading up to the trial. A preliminary inquiry is a hearing that's used in some serious cases to determine whether or not there's enough evidence to proceed to trial. If there is a preliminary inquiry, that may be one way of preserving some evidence. So I do note that not all trials involve preliminary inquiries. And there may be pros and cons to having one. So while it may be a way of documenting evidence from an elderly witness early in the process, on the flip side, it can also add to the time that it takes to get to a trial. So a prosecutor may opt instead to try to get a trial at an earlier date. It's also possible to have evidence from an elderly witness taken in advance of the trial by a commissioner. Generally, this would require showing that the witness is unlikely to be able to testify at the trial due to their poor health. So I would now like to kind of step back beyond the policy and legislation and talk a little bit about how we can move beyond just thinking about those aids and accommodations to ways to fully support vulnerable adult victims as much as we can. So there are steps that can be taken to create a more trauma-informed approach to supporting vulnerable witnesses. Taking these steps can help a witness to be more informed and have more agency in the process. For example, just letting a witness know that they're likely to be questioned on inconsistencies in statements can help to prepare the witness for court. So it doesn't have to necessarily be done in a way that makes the witness feel uncomfortable with testifying so much as done in a way that helps them to prepare to deal with how to address that in court. Informing witnesses about possible accommodations can give them an opportunity to have some choice in what supports they feel they need or appreciate. And there's ways to look for opportunities for a witness to have a say in timing. So this might just be letting them know that they can request a break if they need it. seeing if there's a way to schedule them in the morning or afternoon, if one of those times is better for them than the other. I mentioned earlier the importance of explaining the role of the Crown so that the victims are clear that the Crown is not their advocate, and they have a clear understanding of what their role is in the process. It's also really helpful for a witness to have an understanding of their own role in the process. So if witnesses will often have a way that they want to tell their story and the information they want to get out. If they have a clear understanding of what their role is in the trial and what information the court needs from them, it can help them to stay focused in testifying, which in turn can minimize the need for lawyers to jump in and try to redirect them, which may interfere with their recall and their ability to give their best evidence. There's other things that can be done to try to make sure that support people are available. Is there space to debrief after their interview or testifying? Making sure that the witness is able to have a clear idea of what those supports look like. And so I want to just touch briefly on the approach that's taken in the UK as a different approach, and maybe one to look to as setting a high standard for trying to put the witnesses' needs and strengths first. So in the UK, there's a process called a ground rules hearing, and it's legislated into the criminal procedure rules. And so some common approaches to questioning witnesses, as I mentioned, can be at odds with social science research on how to get the most accurate testimony from a witness. And the ground rules hearing process that's been adopted in the UK allows for some direction in advance to be given from the court on framing of questions in order to obtain the best quality evidence from a witness. So it creates an opportunity for judges to make directions for the fair and effective treatment and participation of vulnerable witnesses involved in a trial. And it applies to complainants, defendants, as well as other witnesses in a trial. The legislation states that the court must take every reasonable step to encourage and facilitate the attendance of a witness when they're needed, and to facilitate the participation of every person, including the defendant. And they can make orders, and directions. So some of those may look similar to the ones that we just looked at that are available in Canada in terms of aids and accommodations that could be employed in the courtroom. But it goes beyond that to also look at the potential directions regarding the manner of questioning and the duration of questioning. The rules also provide for what they call an intermediary to be involved if needed. So an intermediary in this context is a registered communication specialist whose role it is to help vulnerable witnesses and complainants to give evidence to the police and the court. It may be a social worker or speech and language therapist who's registered to assist with two-way communication between the witness and the court or police. And this approach really focuses on requiring advocates and the court and the lawyers to adapt to the witness, not the other way around. And it really focuses on trying to meet the witness's communication needs and abilities. And I point this out as another model, another approach, but also a way to think about, as we've gone through the aids and accommodations that are available in Canada and the approaches that can be taken to communicating with a witness and supporting them through trauma-informed approach. How can we employ some of what's being done in the UK into our approach here in Canada? So not necessarily with a legislated ground rules hearing, but just as a model of how we can think about communication with witnesses and how to support them in terms of getting their best evidence. So with that, I think we can move on to questions. I guess before we do that, I do want to thank our funders. So the research that we're doing on Crown policies is funded by the Council to Reduce Elder Abuse BC, and this outreach work has been supported by the Department of Justice Canada. Just a note sort of to kind of sum everything up. I think that the research overall indicates that there is a gap, at least in reported cases of prosecutions of elder abuse in areas where the social science indicates that there is actually an increased risk of violence. It also shows that testimonial aids are not used frequently to support adult and elderly witnesses. So hopefully this kind of just opens people's minds a bit to what some of the options are and some of the approaches that can be taken in supporting vulnerable and elderly witnesses in the criminal justice process.
Thank you so much, Megan. That was really interesting. And I have many questions for you, but I think we already also got a few from our audience members. So we have Carla, who has several questions. One, I think you partially answered a little bit later on, but the question was, can a good friend come to help a witness or a victim in court to help them speak, or to help speak for them if they can't or are feeling challenged or triggered, or is this a possibility?
Right. So there's a few different things to that question. So someone can ask to have a support person present with them in court. A few key things to keep in mind is that friend or support person can't also be another witness in the case. So there are some restrictions sometimes on who that support person can be if they also have knowledge of the case. There, at least in terms of the courtroom evidence, I'm not aware of a situation where that support person could speak for or help interpret for the person who's giving evidence. So an application would have to be made in advance to the court if a communication aid is needed. What that friend could do possibly is if that person is very familiar with how the witness communicates effectively, is to help inform that application. So providing the court and the Crown with information about how the person's strengths and needs and the way that they can communicate effectively, so that that can be employed through court. But if it is with an interpreter, whether another language or sign language interpretation, there are court interpreters who do that interpretation. But it may be that the court could look at technology assisted communication as well.
Okay, great. And Carla actually had a follow-up question. There are three questions. So the second one is, do the same rules and suggestions that you kind of outlined for us today, do they apply to a human rights tribunal process?
No. I'm just, yeah, so the processes and rules that I focused on today are specific to the criminal justice process. The one piece of legislation that I referred to that would apply to other trials is the Canada Evidence Act. But each, in terms of a human rights tribunal, they're going to also have their own rules and procedures that would apply in that context.
Okay. And the third question that I kept for the end from Carla, because I think it might be a slightly kind of veering into a different realm, but it's, how much better would a victim do if they have written records of what happened from around the time the offenses took place? Is that
so
answering?
So I mean, I can't predict how much better someone would do, but if a witness has given a written statement, a verbal statement, a statement of some sort early on in the process, or that they have a documentation of, that can be something that they refer to refresh their memory when they're coming to the time of the trial. They can refer to those statements, read through them, to try to recall. Now, when they get into court, they have to give their evidence in court to the best of their recollection on that particular day, subject to some of the exceptions that I pointed out, with possibilities of video recorded evidence or evidence taken by commissioner being admitted in some discrete situations. I hope that helps answer the question.
I think it does. I hope it does.
So it may just serve for helping with recall.
Great. We have a question as well regarding if there are any reports or any information out of BC that captures statistics in criminal charges that are filed on fraud or other crimes against older people. Any charges approved by Crown, any convictions? Do we know anything?
So I've been going through a lot of stats. I haven't come across anything specific to BC in that regard. There was a study done by the Ottawa Police Service that looked at cases that were reported to the police in Ottawa involving elder abuse, and the number of those that were then referred to Crown and went to trial. And that study did find that very few of them did end up going forward to be prosecuted, and it drew various conclusions as to why that was. Some touch on some of the things I've touched on here in terms of that often it involves a family member, and there may be concerns with that. Through doing this research, we've been doing some informant interviews, and through those informant interviews, we've heard that very few cases that are reported are making their way to being prosecuted, out of concern for, again, some of the things I've mentioned around the relationship between the victim and the complainant. Sometimes both of those people are elderly and both of them experience dementia or memory loss, which can really complicate the situation. I do think that the intimate partner violence policy that I mentioned deals with some of those issues really well in terms of some guidance. And that's why one of the reasons I wanted to mention it, because that is something that happens sometimes in the context of intimate partner violence. It can be challenging to decipher who in the relationship is more of the aggressor if there's sort of an allegation of mutual violence. So there are resources in the policy that can help with that decision making. I think it's just kind of being aware of that it's there, and referring to it. So to get back to the question about stats in BC, there's a lot of the research has kind of pointed to some of these gaps in what's reported and in terms of case law and the social science research around rates of violence and victimization, as opposed to stats that are collected by the police. And the problem with that, I guess, is that we don't always know what happened. Where along the way was a decision made to not continue with the case along to a prosecution? It's not always in the best interests. And so there may be a wide variety of reasons why any particular case did not move forward for prosecution.
But so these things are not always documented in a way that is publicly available?
That's yes. Yes. And
so
if anyone has come across anything different that contradicts that, please let me know. And I will note that we are continuing to do this research. So if anyone in this audience has experiences with supporting vulnerable adult victims through the criminal justice system that you would like to share with me, please, my contact information was on that last slide, and the slide deck is available. You're more than welcome to reach out to me, and we would like to hear those stories, hear what has worked or not worked. Also, if there's positive stories about supporting someone who's been able to employ accommodations and aids in their trial, because not all cases get reported too. And so there isn't always a public record of what's happening.
Yeah. So kind of following in that line of questioning, we have Dr. Gloria Gutman, who was asking how many elder abuse cases have in fact gone forward in BC, and what type of abuse and neglect are they? Have you come across any specifics?
So not BC specific. There have been studies of reported cases across Canada. The elder abuse cases that are reported, the vast majority are ones that involve high levels of violence perpetrated by a stranger, which, if we look at the social science, is the vast majority should be the family situation of elder abuse, and those ones are not reflected in what's published and available publicly.
So we don't have a whole lot of time, but we have one more question that is asking, and I think that touches more on the idea of training of professionals who are in the legal system. It's how do you get police to shift from writing a lot of the elder abuse reports as civil, from saying it's a civil matter, because if it's a civil matter, then they won't investigate, then the whole thing goes unchecked. And are you aware of a change in the process or trainings that are starting to maybe change those ways?
Yeah, so we, as part of this research, we requested to be able to interview Crown Counsel about some of their training and employment of the policies, and we weren't granted that opportunity. So we're relying a lot on what's publicly available in the public record in terms of information informing this research. In terms of shifts in mindsets, I think that the realm of intimate partner violence is one where we see that just the length of the policy in the BC Crown Counsel manual, I think is, I'm going off of my memory here, I think about 4 times longer than the elder abuse policy, significantly more detailed, and touches on a lot of these aspects of the increased vulnerability and how to deal with it. So I think that when we're looking at family and intimate relationships, that's a model to look at as sort of like how some change has been affected in that realm. And now maybe we need to just take the step further of recognizing that this is something that also impacts the aging population, and to a great extent women who have dementia.
Absolutely. And I had a question, because you did mention the importance of the trauma, being trauma informed in order to understand how one processes memories, et cetera, and how that can change how we approach a witness or a victim. Are you aware of any training that has to do either with dementia or with ageism along the same lines? Because those are 2 factors. I think understanding how dementia impacts the brain and behavior, and understanding biases that we may have about older people could really change how we process or kind of lead someone through that whole legal process, and whether or not we consider them credible.
Yes, so I'm not aware of training materials within that context of, I guess, dealing with trauma, and specifically the impacts of aging and stereotypes that are drawn in that context. There is a great resource on taking a trauma-informed approach for legal professionals. There's a toolkit put out by Golden Eagle Rising.
I'm sharing the link in the chat
Thank
box
you.
again right now.
And I think that is a really helpful resource for anyone who's supporting someone and going through the legal system in terms of understanding the impacts of trauma, and then just applying a recognition about how aging and additional stereotypes applied in that context compound that. But ultimately, employing those tools that are there is what could really support someone. So I don't know that the tools would change a whole lot so much as just kind of the raising the awareness of how we perceive elderly people, and also that some of the natural age-related effects added to a traumatic event can just compound those challenges. But there are those ways of supporting through more supportive communication approaches and just trying to build trust.
And that takes time, which is
It does.
something that is rare in those processes too. I think that's all the time we've got, because I know Rayanne wanted to say a few things before you all go on with your day. So Rayanne, please jump in. Thank you so much, Megan.
Thank you.
Great. Thanks, Megan, for a great overview of the, losing my voice. Great overview of the presentation of the criminal aspects and things to consider in terms of, going through the court system. It's, there's some great questions as well, and I know we didn't get to all of them, but if we need to do a secondary one, as Benedict mentioned, then we would more than be happy to do such a thing. I do want to just let people know of some upcoming events that we are hosting. So we're talking, when we're looking about, criminal offenses and victims, one of the things that many people aren't very familiar with is risk assessments, that we can maybe prevent some of these tragic sort of situations happening. So we're hosting a risk assessment training with Dr. Jennifer Story, who is a senior lecturer in forensic psychology at the University of Kent. And so that's actually this week. So if anybody is free for the next couple of days, and on the 17th and 19th is interested in participating in this hands-on sort of training, please go to our website and you can register there. This is also part of our work that we're doing with the Victims and Survivors of Crime Week. We also have a session coming up next week on safety planning for older women experiencing violence as well. Again, it'll be from 1 till 2 o'clock in the afternoon. These are all posted on our website as well. And then the following day, we're actually talking a little bit about the trauma-informed approach, but also talking about vicarious trauma of dealing with some of the situations and how we do better at our personal care, looking at our personal and collective approaches in our care for ourselves, so we can continue the work that we do. So we have a keynote, Karine Silverwoman, who's going to be she's also a trauma-informed specialist, or therapist, I should say, who's going to lead that session as well. And of course, our big event that Benedict, myself, and CanAge and the BCCRNs were hosting on June 15th for World Elder Abuse Awareness Day. We're excited. We're going to be launching our speaker lineup in the next day or two for people to get signed up. You can go on our wead.ca website and register now. So we're looking forward to everyone participating and getting engaged, and you can find resource materials on our site, on Benedict, on CMPA site, as well as the wead.ca and all the partners. This is a big event, as everyone knows. It's a global initiative that we want to increase awareness and really promote the rights don't get old.
On this note, I think we are. Is there any more? Oh yeah, there's more.
No, sorry. There's just a couple. These are Ontario resources in terms of some of the legal. You were talking about legal resources. So we do have the Advocacy Center for the Elderly in Ontario, the Law Society Referral Service, the South Asian Legal Clinic, and also the Office for the Public and Guardian Trustees for those individuals who are at risk and experiencing abuse, so they can get involved in intervening and supporting the older person. Just a reminder, we do appreciate you filling in the evaluation at the end. Just taking a couple minutes to give your feedback. Our contact information, this is Elder Abuse Prevention Ontario. This is my contact. You can go to our website, get information. We're on social media. Again, our handle is right here for people to access. If you just search up the name, it'll come up as well. Benedict's contact information. Don't forget to look up the Future Us document. Very good resources, good timing for people to get engaged in Seniors Month to, you know, start the conversation about abuse prevention, no matter what your capacity is as an individual or citizen, government, agency, researcher. We all have a role to play in terms of, you know, looking at the prevention of abuse across Canada. And that's the conclusion. So thank you all for joining. Thank you for our interpreters for joining us today. And most of all, Megan, for taking the time out of your busy schedule to share your experiences with us. Just as a reminder, we will be posting all the links that Benedict shared in the chat box today on our website, so you will have easy access to them. Just give us a day or two to get that up, and it will go out to you as well. So thank you all, and we will see you at future webinars and sessions. Thank you.
Have a great day, everyone. Thanks.